have a second part of the previous class, which was on Domestic Violence Act and Senior Citizens Act. But today in this class, we will discuss the case of S. Vanitha versus Deputy Commissioner Bengaluru Urban District. Urban District. It's a civil appeal, and we will discuss this case because in this case there's an involvement of both of the act which we have discussed in the previous class. That's the Domestic Violence Act and the Senior Citizens Act. So moving further. Okay. So in this case, Supreme Court talked about harmonious construction of Senior Citizens Act and Domestic Violence Act. So first of all, why Supreme Court has discussed the concept of harmonious construction and what is the meaning of harmonious construction and what is the need for Supreme Court to discuss the concept of harmonious construction between the Senior Citizens Act and Domestic Violence Act. So there is a rule of harmonious construction, and we will first discuss when the rule is when by which we can decide that whether there is a use of this rule or not. So when there is a conflict between two or more statutes or two or more part of the statute, then the rule of harmonious construction needs to be adopted. So the rule follows a very simple premise that every statute has a purpose and intent as per law, and that statute should be read as a whole. So the interpretation consistent of all the provisions of the statute should be adopted. In case in which it is impossible to harmonize both the provisions, the court's decision regarding the provision shall be prevail. So the rule of harmonious construction applies when there is inconsistency between either two provisions of the same statute or between two different statutes. So when there are two provisions in a statute which are in apparent conflict with each other, they should be interpreted such that effect can be given to both. So it's very important to note that both the statutes, if there is apparent conflict, then both the statutes should be interpreted such that the effect can be given to both. And that construction which renders either of them inoperative and useless should not be adopted except in the last resort. So first the court should try that the effect should be given to both. Okay. So the court must avoid a head-on clash of seemingly contradictory provisions, and they must construe the contradictory provisions so as to harmonize them. That's why the rule is known as harmonious construction, because the rule aims to provide a harmonious relationship between two conflicting or between two or more conflicting statutes or acts. So court must also keep in mind that interpretation that reduces on provision to a useless number or a dead number is not harmonious construction. And they should give effect to both the statutes. Okay, and to harmonize is not to destroy any statutory provision or to render it loose. To harmonize is to construct or interpret particular statutes in a manner such that both will have their effect and both works effectively. It doesn't aim to destroy any statutory provisions unless and until means this can be done in the last resort. So first court should try to harmoniously construe the statutes. Okay, so this is known as harmonious construction, and we will check in this case by the after discussing the facts, we will check that how comes the need of harmonious construction of Senior Citizens Act and Domestic Violence Act. We have discussed both the acts in the previous class, and we know both the acts have their own topic area, means they have their own subjects. Domestic violence deals with the wife or the husband, and the Senior Citizens Act deals with the senior citizens, means citizens which are above than 60 and or parents. Okay. So today we shall discuss a latest judicial pronouncement by the Honorable Supreme Court of India, which is S. Vanitha versus Deputy Commissioner Bengaluru Urban District and others, 2020, wherein the scheme of the Maintenance and Welfare of Parents and Senior Citizens Act 2007 and how the same has to be construed qua other enactments was discussed by the court. Okay. So, is first thing, just let me know that is concept of harmonious construction clear to you guys? If there is any problem, you can mention the question in the chat box if it's related to harmonious construction. Okay, so we are moving further. So now we are on the facts of the case. So in the present case, an application was filed by the parents of a person who sought to evict his estranged wife and children from a residential house belonging to the parents, which is the mother. Such application was allowed by the courts below. Below means the High Courts, District Court, Session Court, Civil Courts, other courts. And thereafter, the matter travels to the Honorable Supreme Court of India. Okay. So an application was filed by the parents of a person who sought to evict his estranged wife and children from a residential house belonging to the parents. Okay. So now, while discussing the facts, we will check. See, we will check that where we will check and we will try to find the conflict between the Senior Citizens Act and between the Domestic Violence Act. So we know that Domestic Violence Act is to cater the problems involved with wife or with husband and maintenance and maintenance and welfare of senior citizens and parents act is there to cater the problems faced by parents and senior citizens. Both have their own area, but one thing is most important that though both the acts have their own area, but then also both their area coexist in the normal life. Let example of a family. In suppose take the example of the joint family. In joint family, what happens? Senior citizens and the wife and husband resides at the same place, reside in the same house. So in the normal life, though there are two acts dealing with two different subjects, but then also in the normal life, all the laws are correlated. Most of the time, most of the laws are correlated, and especially in this case, the Senior Citizens Act and the Domestic Violence Act, though their subjects are different, but then also their subject have relationship in the normal life. So uh, so what will happen if there is a problem in which both the acts have their role, and not only this, they have their role in the contradictory position. So we'll check now what will happen. Okay, so according to the facts, what happened that the person want to evict his estranged wife, means throw the wife wants to throw his wife out of the house, and the house belongs to the parents. Parents wants related the, in this case what happens that the parents, and through their son, they want to do this thing, and the parent wants to throw the wife out of the home, and because the property is of parents. Okay, but the wife wanted to stay in that place because wife can't go at any other place. So because she was married to the person, so she wanted to stay at that place. So she filed an application under the Domestic Violence, and the parents filed the application under the Senior Citizens Act. Okay, so now see the contradictory position. So we will check what was decided. We will check the reasoning. We will check both the acts. We will check the summary of both the acts, and then we will check what was held in this case. So moving further. Okay. Now, let's check what is the chief contention of the appellant. Appellant means estranged wife. In this case, appellant was estranged wife. Because earlier the lower courts but have decided the case in the favor of parents. So it's obvious that the appellant will be the estranged wife. So the appellant estranged wife is residing in her matrimonial home, in the home in which she was married, which is a shared household. Shared household, take the example of joint family in which every person, in which even the parents, grandparents, grandsons, and wife of grandchildren and wife of parents live. So it's a shared household as a lawfully wedded spouse of the son of the parents who moved the application under the Senior Citizens Act 2007, and she cannot be evicted in view of the protection offered by Section 17, right to reside in a shared household, of the Protection of Women from Domestic Violence Act 2005, in short, Domestic Violence Act. So She claimed that it is a shared household and she is a legally wedded spouse. She is not illegal spouse. She is a lawfully wedded spouse of the son of the parents of the parents, and those parents have moved the application. Initially, the parents have moved the application in the court against which she had appealed. So the parents have moved the application under the Senior Citizens Act as the property was owned by the parents. So they have moved the application under Senior Citizens Act, and she has claimed the protection for living in that matrimonial shared household. She had claimed the protection under Section 17, which gives protection to a lady, which is right to reside in a shared household. Okay, protection is of right to reside in a shared household under Section 17 of the Domestic Violence Act 2005. So the appellant, estranged wife, has no other place to live except the suit premises, means except that shared household, except that matrimonial home, which was talked in the suit. So it was named as suit premises, except the suit premises, and relied upon Section 17 of the Domestic Violence Act, urging that the Senior Citizens Act cannot be invoked to evict her. Okay, so this is the total contention of the wife appellant. Now moving on to now we have moved on to the chief contention of the parents and respondents. So parents and respondents are senior citizens. It's very obvious that they are senior citizens. In the case, it's clear there's no conflict or no contradiction on the point that they are senior citizens or not. It's very clear in the case that parents and respondents are senior citizens, and the suit premises was constructed by their ancestors. Okay, suit premises was constructed by their ancestors, by the parents' ancestors. So it has been an ancestral property. And while discussing the Senior Citizens Act, we have discussed the types of property, in which we have discussed the movable property, immovable property, tangible property, intangible property, and also about ancestral property, which was passed by ancestors. Okay, so the property was the ancestral property of the senior citizens, and they also claimed in the Supreme Court that there are concurrent findings by all the courts below who have directed for eviction of the appellant and restoration of their possession. So means they held on they protected themselves by the decision of the lower courts. They said that earlier lower courts have decided, and if they have decided, they must have decided on some merit. And Supreme Court, before giving and before approaching on a particular decision, should try to understand the merits, the way, the reasoning applied by the lower courts. Okay, so this is the contention of the parents and respondents. Parents, which are the respondents in this case. Moving further. Okay. So as the contention was made by the parents, let's have a brief summary of the Citizens Act 2007, which is Maintenance and Welfare of Senior Citizens and Senior Citizens and Parents Act 2007. So Section 2, Clause B of this Act provides under definition of maintenance we have discussed, which includes the provision of food, clothing, residence, medical attendance, and treatment. We have discussed it in point while discussing the Act. Section 2, Clause F discusses the property, which we have just now discussed, immovable, movable, ancestral, self-acquired. Yeah, I missed that time, a point I missed, that's self-acquired. Property can be self-acquired also, tangible or intangible, and includes rights or interest in such property. Then Section 3 provides that this act shall have an overriding effect on the other enactments and acts. Means it will have a dominating effect on the other enactment and acts. Though it was written in the act, but now it's a duty of the Supreme Court and the High Courts and other courts to interpret this section and to tell and to explain what is the clear meaning of overriding effect. Means to tell whether the act is in dominating position or what should we consider the meaning of the overriding effect, the term overriding effect. So moving on to Section 4. Section 4 states it recognizes an entitlement of maintenance to inherent parents and senior citizens. Section 5 states that it lays down the procedure by which an application for maintenance can be made. Just the procedural law started to come. So the procedure. Now Section 6, it elucidates provisions governing jurisdiction and procedure. Section 7, it contains stipulations for the constitution of a maintenance tribunal. So what we have checked that in senior citizen, the matter doesn't go to court. There you don't need any legal representatives there in the maintenance tribunal of the Citizens Act. There are different tribunals made totally for the issues faced by citizens and totally for the issues faced by senior citizens and parents, and it's totally different for the court from the court. So it contains section 7, it's mentioned that it contains stipulations for the constitution of a maintenance tribunal. Then section 8, it envisages a summary proceeding for making an inquiry. Okay, so what is summary procedure or summary proceeding? So summary suit or summary proceeding is a unique legal procedure used for enforcing a right in an efficacious manner as the court pass judgment without hearing the defense. So court can pass the judgment ex parte also. Ex parte means in the absence of the party. And here in the summary suit, what happens? Summary, it means a summary suit. Means the full suit is not covered. When the full suit, so when was the full suit covered? Full suit will be covered when there are both parties in the court, when the both parties are involved in the trial. But here, summary proceeding or summary suit is a suit in which the other party is not present and Supreme Court has passed that decision without hearing the defense. Means by hearing just the prosecution, by hearing just the blame and the claims made, Supreme Court has passed the judgment. Okay, so these kind of suits are known as summary procedure or summary suit. And section 8 envisages a summary procedure for making an inquiry. So summary procedure or summary suit, there is an option of summary procedure in this act. So moving on to section 9. Section 9 states that there will be monthly allowances can be fixed by the tribunal for the maintenance of the senior citizen. It's obvious. Moving further, section 10 states that the above stated monthly allowance can be altered upon a change in circumstance. So as we have discussed while discussing section 125, that when a wife claims maintenance from the husband, then that amount of maintenance also can be allowed or altered upon a change in circumstance. Suppose the husband claimed maintenance from the wife and wife has been getting 80,000, and then after some time due to the lockdown and due to the COVID-19 pandemic, the salary of wife decreased and it came down to 20,000. So suppose if the husband was getting the maintenance amount as 20,000 at the time when wife was getting 80,000, then now if the wife is getting 20,000 herself, then how can she provide the total salary to the husband? Then the amount of maintenance can be altered or can be removed or revoked also. Okay. So in the same procedure, suppose the son or the daughter of the parents or the senior citizen is getting 1 lakh rupees per month, then and after some period of time they start getting 20,000 or 30,000, then the amount which they are paying as a monthly allowance to the senior citizens or to the parents can be changed or altered. So this is the provision under section 10. It's clearly mentioned in the act. Moving on to section 11, it provides for the enforcement of an order of maintenance. Then section 23. Section 23, we have discussed it in a detail. That section 23 states that if a senior citizen gives any property to any person, subject to the condition that such person shall take care of the basic needs of the senior citizen, and when such person does not provide for and take care of the basic need of the senior citizen, then the said transfer of property shall be deemed to have been made by fraud or coercion or undue influence and can be declared void by the tribunal. It further provides that where a senior citizen has a right to receive maintenance out of the property, if the transferee has notice to the right and the transfer of such property is without consideration, then the senior citizen has a right for the property. Okay. So what happens before this act? Before the act came into existence, the only remedy available to the senior citizen in such a case was to approach the court to ask for the maintenance from the children to whom he had transferred the property. But then also such property would be the exclusive property of the transferee. Means exclusive property will be the exclusive property of the sons or daughters of that senior citizen. But then and the senior citizen had no right on such property. But now here after this act, the transfer of property will be null and void. Okay, if the conditions are not fulfilled. So by applying the provisions of this act, a senior citizen can reclaim his property from the transferee. It's this much is clear about the Senior Citizens Act. These are the main provisions of the Senior Citizens Act which we have discussed. So now, let's come to our original case which we are discussing, Vinita. So in the Vinita one, they are talking about the ancestral property, and it's very clear in this case that they have proved also. Senior citizens have proved in the court that it was their ancestral property and they have acquired and they have the right on it. They own it. Okay, so the ancestral property is owned by the senior citizens. Okay, means in this case the parents. So now, as you all know the facts of this case, and as you all know the brief summary of both the acts, then can anybody answer the question that what do you all think that what will be the decision of the court? Will the wife be allowed to live in the house which was her matrimonial house and which was her house, and the wife will be allowed to live in that particular house? And you should keep in mind that the house is the ancestral property of the parents, and they are claiming their house, and they are trying to uh, throw the wife out of the house because it's their own property. So can anybody tell it in the chat box so that what do you all think? Because if I just explain it on the basis of the judgment and on the basis of the reasoning, then you will just have a simple pie. I mean, just apply your mind, and after applying, can anybody tell it in the chat box that what do they think? I will wait for 2 minutes and then we will proceed. If you explain, then please explain with the reasons also. So it will be better for you also to digest whatever we will further study about the reasoning of the court and what was held by the court. So what do you all think? The same facts can also be a part of your question while in the CLAT or in the ILET. Means they take the facts from the real cases, so these kind of facts, so you should start applying your own mind. Great, there's one answer that woman has the right to live in her matrimonial house and the parents can't just throw her out. Okay, then also Gargi, just give me the answer of the question that the if we check it legally, if we make a legal approach without getting into emotions, then though they means the properties of the senior citizens is of the parents, and you have the right on your property. Means you can decide that who is going to get benefit from your property, who is going to live in your property. So then they have the right. Means if you have the property, then you have the right to decide who is going to entertain, who you are going to entertain in that property. Then Gargi, I hope that others will also provide their own answer. I will wait for 1 to 2 minutes. Means I will wait for 3:20 till 3:27, and then we will move. Though, it will be better for you all to provide the answers, because then only you will apply your mind, and then after that we will check that what court held. So if you are wrong also, it's not a problem. If you are wrong, then you will get the reason, and you will get the right approach. Okay, so she lived there because she is married to the parent's son. Okay, that's why she has the right to stay there. Okay, we will check. We will check this thing. Though it's a great point for defense, from the side of the woman, from the side of the parent, it's a great point. Then it would deprive the daughter-in-law's right. Okay, it will deprive the woman's right who got married. Okay. So it is an ancestral property of the senior citizens who can make decision that who need to enjoy their property. If it is partitioned property and it is partitioned under the name of husband, she can live there. Though great approach from Bhuvisha. Okay. So that's why there is a contradiction. Now, after applying your mind and after giving you all, after as you have given your all reasonings, so now you can clearly see that there's a see the woman has the right to live in that house as per the Domestic Violence Act, because we have checked the section 17 of the Domestic Violence Act. Huh? Wait, uh, we have checked here that the section 17 provides right to reside in the shared household to the woman as per the Domestic Violence Act. So, if as the woman has also taken the approach under the Domestic Violence Act, and thus the woman has the right to reside in the shared household under the Domestic Violence Act. But if we move to the Citizens Act, then we know that where the property is defined under Section 2F, it clearly defines the ancestral property. And yeah, but Bhusha, 1 second, let me open the chat. Wait. Wait, yeah. So, as Bhuvisha has mentioned in the chat, that if it is partition property and it is partitioned under the name of husband, she can live there. Okay. So, in this case, what happened that the property is not partitioned, and property has till now it has not been till the case was there, it has not been allotted to the husband. So, it's totally under the ownership of the parents. So the parents get the right of the ancestral property under the Citizens Act 2007. Okay, so they get the right under the Citizens Act, and the wife has the right under the Domestic Violence Act, section 17. So now you can understand, yeah, there is a contradiction between the two acts, and what is the duty of courts? We have discussed that there is a concept of harmonious construction, and the court should try to harmoniously construct both the acts. There is one more answer. Let's check that also. So yeah, Senior Citizens Act does not allow to evict their daughter-in-law, as it would deprive her of the rights in a shared household under the Domestic Violence Act. Okay, so let's go in a bit detail that what all is allowed by Senior Citizens Act. Okay, let's understand the words also. So Senior Citizens Act to allow the person to have the property, to entertain the property which the person has. Means you have the right you have the right of the property which you have, either the intangible property, tangible property, either the intangible property, tangible property, or the movable, immovable, or ancestral property. And just from this point, the second right emerges, and that second right, that's the indirect right, but it's very major right. If you have a right to a particular property, then you have a right to decide who lives in that property. Means, suppose, just take an example. Uh, Suppose the president house. Let's take the example of president house. The president house, now the current president has the right to live in that particular house. So it's under the right, and it's under the right of the president to allow someone to live in that house or not. So president can throw someone from that house. Just take a simple example of any house, or take your example of your neighbors also. Neighbors have the right of their own property, and they can throw you out if you enter there, if you trespass in their house. So from there, the senior citizens get the right to throw the wife out of the house. Okay, okay, Anashura, it's okay. If it's clear, then you can mention yes in the chat box, so we can move further now. Okay, okay, okay. There's a gender issue, but okay. Yeah, yeah, okay. Great. So moving further, let's check now that what Supreme Court decided, and how much Supreme Court is clever while deciding this matter. Okay, let's check that. Now, there is one more trap in this whole issue. That's the means and includes thing. So we will decide the approach and the interpretative process of means and include. So let's first check what is the interpretative process is. Okay, let's understand first the interpretation, the way of interpretation is how one should interpret anything. Okay, so this is relevant for enactment wherein a definition has been provided that involves usage of means and includes. So under a book of principles of statutory interpretation by Justice G.P. Singh, it was observed that the legislature has the power to define a word even artificially. So the definition of a word in the definition section may either be restrictive of its ordinary meaning, or it may be extensive of the same. When a word is defined to mean such and such. See, in the definition provided in a particular act, we know that there are certain, like we have discussed the definition of the property, we have discussed the definition of the maintenance. So in the act, there are certain words which are defined. So when a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. It tries to restrict the definition, particular definition, by adding the word mean in that particular word definition. Okay. So moving further, whereas where the word defined is declared to include such and such, the definition is prima facie extensive. When by an amending act the word includes was substituted for the word means in a definition section, it was held that the intention was to make it more extensive. Okay, so now include means more extensive, and means more restrictive. Okay, so whenever means is used, if you in the future also, if you read any act or read any definition clause in the act, then just keep it in your mind that if there is word means is used, then it tries to restrict the definition, and if the word include has been used in the act at a particular definition, then it's trying to make the definition more extensive. Okay, moving further. Now, means and include approach and the interpretative process. So the means and include approach has been discussed in plethora of cases earlier in the Jagir Singh versus State of Bihar. It was observed as under that further definition may be in the form of means and include, where against the definition is exhaustive. So till now, what we have discussed only about means, and we have discussed only about include. But there can be definition also in the forms of means and include. If the definition is in the form of means and include, then the definition will be exhaustive. Okay, so in at the time of means it's restrictive, at the time of only means, when the only means is used, then the definition is restrictive and exhaustive. When include only and only include term is used, then the definition is extensive. And when the means and include both the terms are used, then the definition is exhaustive, and it is held in the Jagir Singh versus State of Bihar. It's the norm now that when means and includes both are used, then the definition is exhaustive. So now we will discuss. Okay, now we will check section 2S of the Domestic Violence Act, and then you will get to know that why till now we have been discussing mm, the pointer means and include definition. Okay, so section 2S of the Domestic Violence Act defines shared household. Wait for 1 second. I will be. Okay, so here is the definition of shared household. I hope you have read it. So shared household means, here the first word it means, okay? So shared household means a household where the person agree lives or at any stage has lived in a domestic relationship, either singly or along with the respondent, and includes such a household whether owned or tenanted either by jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent or both jointly or singly have any right, title, interest, or equity, and includes. Okay. First, they have used the word means, and now they are including something in that particular definition. So, and includes such a household which may belong to the joint family. Now the point has come. Till now, till previously we have been discussing the ownership of the house, but now after the coming of the term include, we are discussing such a household which may belong to the joint family of which the respondent is a member, and this is the case now, irrespective of whether the respondent or the aggrieved person has any right, title, or interest in the shared household. Okay, so that's why we have earlier discussed the means and includes terms, okay, and their way of interpretation. So in this act, the problem is that first, while using means, they have discussed the ownership, that the house should be owned or tenanted either by the aggrieved party or the respondent, or owned or tenanted by either of them. So we have discussed about the ownership and the tenancy. In the tenancy also there is ownership. But after the word include has been used, after the term include has been used, we have discussed the property which belongs to the joint family, means which belongs to the parents, which belongs to the grandparents. But here, the both the terms means and includes, both the terms are used. So this is a exhaustive definition. Okay, court checked this. And while discussing the fact, we discussed, and also while discussing the contention of the appellant, that's the woman, we have discussed that woman is claiming that it is a shared household. She is living in the shared household, and as per the section 17 of the Domestic Violence Act, she has the right to reside in that shared household. So that's why we came now to the definition of shared household. Okay. So court checked the definition. Then thus, by taking recourse to the means and include approach, it was observed by the court that the definition of shared household cannot be read to mean only that the household which belongs to the husband or of which the husband is a member, and can even include the household belonging to any relative of the husband with whom in a domestic relationship the woman was lived, or the woman has been living in the past. Okay. So this is the way of approach of Supreme Court. Further, now Supreme Court has harmonized the Senior Citizens Act and the Domestic Violence Act. And how? Section 36 of the Domestic Violence Act provides that the provisions of the Act shall be in addition to and not in derogation of the provisions of any other law for the time being in force. Okay. Just notice it that section 36 of the Domestic Violence Act provides that the provisions of the Act shall be in addition to and not in derogation of the provisions of any other law of the time being in force. Therefore, the domestic violence is in addition to other remedies and does not displace or override them. However, Section 3 of the Senior Citizens Act is unequivocal in its approach. We have discussed Section 3 while we are discussing the summary part of the Citizens Act. We discussed Section 3 that in its it's unequivocal in its approach, the Section 3, that the Senior Citizens Act shall have an overriding effect over all the other enactments. It's unequivocal because Constitution is also an enactment. And does the Senior Citizens Act has an overriding effect on the Constitution also? on the IPC also, on the Contracts Act also, on the Arbitration Act also. So it's unequivocal. It doesn't provide any alternative. It has clearly stated that it has an overriding effect, but it's clearly mentioned in 36 of the Domestic Violence Act that it's not overriding. It's not in derogation of the provisions of any other law for the time being in force. It's just an addition to it. Okay, so that's why the section. So we will check further now. Now let's check what the court has observed. So the court observed that both the Senior Citizens and the Domestic Violence Act are welfare legislation, and we know that. And there is a need to harmoniously construe them. And we have discussed what harmonious construction is. Then it was further observed that a shared household would have to be interpreted to include the residence where the woman wife had been jointly residing with the husband. Merely because the ownership of the property does not rest with the husband or that of the estranged spouses living separately is no ground to deprive the wife woman of the protection that was envisaged under the Domestic Violence Act. Is this clear? Is this logic clear?
Yes, sir.
Okay. So let's clearly come to the judgment. What the Supreme Court finally said, final remarks of the Supreme Court. The court finally held that whether the suit premises constitutes a shared household within the meaning of the domestic violence or not would have to be determined by the appropriate forum, and such a claim cannot simply be obviated by evicting the such a claim cannot simply be obviated by evicting the appellant wife in exercise of the summary power entrusted by the Senior Citizens Act 2007. I have repeated it just for your sake, so that you can notice the thing. Then, even the parents respondents were given the liberty to move a subsequent application under the Senior Citizens Act. They have also the opportunity. Finally, exercising the power under Article 152 of the Constitution of India, the court concluded by holding that the appellant wife shall not be forcibly dispossessed from the suit premises for a period of 1 year. So she have to be in the have to be there for the period of 1 year, and nobody can remove her from there. And the Supreme Court has passed this to enable the appellant wife to pursue her remedies in accordance with law. Okay. So this is the final judgment of the Supreme Court, and this is the last slide. So now, if everything is clear, then we will move on to the questions. You can access the questions on the portal. I am also opening the file, and then we can discuss the question. So this is the passage. You can access the questions from the portal. And then there are two very small questions. You can term them as legal GK questions. They can also be part of the GK, and they can also be part of the legal. They are very important because the case of Vinita is recent, and due to this case only we have discussed the Domestic Violence Act and the Senior Citizens Act.
I think in the first question, 60 years is appearing twice.
Yeah. That may be a problem. I'm going to just address that problem only. Okay, so you know the answer. That's the most important thing, that you all know the answer. That's the first answer is 60 here, and the second one is section 125, and you have mentioned it correctly. Okay, so there's no need for any reasoning in these two questions. So we can, if everything is clear about the today's case, about the today's factual situation, because it can be a part of your CLAT paper also. The same situation can be a part of the CLAT paper, and it is better if you know the Supreme Court decision, because the paper setters can't move directly away from the Supreme Court's decision. So if everything is clear, then we can end the session.
Thank you, Yash. And we'll be ending the session now.
Okay, ma'am.